Hello viewers, my name is Richard Land. I'm an attorney and a member of the Connecticut law firm known as Chipman, Mizuko, Emerson. This is a sample of part 3 of our 4-part video series on long-term care issues in Medicaid, which we recently updated. I've been the presenter in the past, but now we're changing things up. One of my law firm partners, Allison Marcusio, is the presenter. Allison's special passion is the practice of law that deals with the legal problems of the elderly and of others who have chronic medical conditions and disabilities. She's made it her personal mission to know more and be more creative than anyone else who practices what we refer to as elder law. We want you to get to know Allison and how she may be able to help you. This sample from Part 3 covers the rules that apply if you're thinking of transferring assets to others so that Medicaid will pay for your long-term care costs. So, here's Allison.
Welcome viewers to Part 3 of our screencast on long-term care issues in Medicaid. My name is Allison Marcusio. I'm an attorney and a member of the Danbury, Connecticut law firm known as Chipman Mizuko. In Parts 1 and 2 of the screencast, we talked about the kinds of services Medicaid covers and the asset and income criteria for eligibility for Medicaid. Now in this Part 3, we'll be talking about how eligibility can be jeopardized if you make certain transfers of property in order to qualify for Medicaid. As you may expect, the Medicaid program includes rules that are designed to thwart the perverse incentives to transfer assets so you can qualify for a welfare program. In Part 3 of this screencast, we will be talking about the rules relating to transfers. This is the main idea. If you need Medicaid benefits and you make a transfer, or your spouse makes a transfer for less than fair market value, you may not qualify for Medicaid benefits. In other words, if you make gifts in order to qualify, you may be disqualified. When you apply, the application process will include a review of your records for the previous 5 years to try to find out whether you made any gifts in that 5-year period. If no gifts can be found in that period, there will be no disqualification even though you may have made very large gifts 6 years ago. That's the general rule, that a gift made within 5 years before the time you apply will disqualify you. But there are exceptions, and here they are. You can transfer your home to your spouse, to a child who's under age 21, to a blind or disabled child, to a brother or sister who owns a home with you and who has been living in the home for 1 year, or to a caregiver child. A caregiver child is a child who resides in the home with you for at least a 2-year period before your institutionalization, and who provides you with care which avoids the need for your institutionalization during that 2-year period. That can be a very important exception because it's not unusual for a child to decide to live with a parent who needs help. Before you become eligible for Medicaid benefits, there are no restrictions on your transfers to a spouse. But the only transfer you can make to your spouse after you become eligible is a transfer to give your spouse a community spouse protected amount, which we talked about earlier. And keep in mind that transfers to certain disabled children are exempt.
Hi, this is Richard Land again. I'm back just to say that's the end of this sample from Part 3 on how you can transfer your assets and still qualify for Medicaid. If you'd like more information, you can access the full video at the link in the top right corner of your screen or at the bottom of the email that brought you this video. There, you'll also see the link to the full series playlist entitled Long-Term Care and Medicaid. I hope you found this video informative. Please let us know if you have any questions. We're here to help.